So the first question is, my property is in trust. So would that prevent me from putting my home and land in allodial title? So how do you put your land in allodial title? Do you understand what allodial title is? So allodial title is free of any encumbrance. And so my question to you would be, is your land registered in a county recorder? What is the name of that county recorder? Do you have a loan on that? And all those questions would precede an answer to that question, because we all want allodial. We all want to sit on the patented land that is tax free. We all want to be free of encumbrances, free of where they would have jurisdiction over. That's the dream come true. But the elements of what creates title for an individual is, did they sign did they purchase property, or did they purchase land? Did they register it? Who is their carrying note? So to answer your question in these next 6 questions in one answer, I'm going to explain to you, as first and foremost, as a registered real estate broker, meaning I hold a broker's license in my wallet. I've done in excess of personally 800 loan transactions, corporately thousands. I've had probably 15,000 loan apps go across my desk. I have no idea. Where I reviewed compliance, checked it, went through every element. I've table funded. I've been my own lender, private capital and public funds. I know the loan business probably better than anybody. I created an advanced 9-hour chain of title training that we post for free on YouTube and on hisadvocates.org. I do know a lot about title. That's not to say I'm the guru, but one of the questions on my broker's application or test intrigued me. I mean, really blew my mind, because it happened so long ago. And then I'm like, oh, wow. And it was on the test questions that I did to study for the broker's exam. And it was, are you required to register or record something in the county recorder? And I'm like, oh yeah, of course, you're a slave. And I mean, I didn't think that, but I just thought that was the general answer. The answer that I got, which was wrong, I said, yes, you're required. And the answer is no, you're not required. So my thought process, and I've talked to many real estate attorneys about how to properly have a transaction dialed in, but not record the transaction in the manner in which we currently today record the transactions. And so putting your home into a trust is kind of like level 1 Kevlar protection for dealing with property recorded in a county recorder. Yes, if you were to pass away, it bypasses estate tax and different things and elements of probate. It bypasses the ability to have increased taxation due to the transfer of the title to your children or your wife or your spouse. And so, putting the property in a trust doesn't mean they're not going to come after, like if there's a loan on the property, it doesn't mean they're not going to come after the note holder. They always sue the note holder. They don't care who's on title. It doesn't matter. So to answer your question, which was, my property's in trust, would that prevent me from putting my home / land in allodial title? There is no such thing in this country as putting your land into allodial title. The closest thing that you could do to putting land in allodial title would be to have a patent. All the patents for this nation have been issued. And I want you to think about what I'm about to say. So there's gurus out there that claim that you can be an assignee to a patent. And they claim that possession is 9/10, and it is, of the law, quote unquote. But possession in what capacity? You have to think about that. Possession with a guy who has a note, possession with a person who's recorded in the county recorder, that not the note, but the deed of trust. What is your level of possession? Are you just holding, sitting in a house, and that's your level of possession, and you've got a note on the property, And the original purchase agreement, which, by the way, was never countersigned, you created a self-executing trust. You were the sole exclusive signer on it. You said, I am a renter, whether you want to believe that or not. You recorded yourself as a renter. It's called joint tenant or tenant in common. Those are things that they've tricked us with these words and terms and terminologies. We put 20% down, consideration. We think we're getting into a contract, offer, acceptance, consideration, performance, full disclosure. Those are the 5 elements of a contract. Tell me how any of those are really meant or are completed within a set of loan docs. They're not. We're creating trust. They literally take your note, and I explained it all in this advanced chain of title. Take your note, flip it, and cash it. And they prepay for themselves all interest, all principal through the Federal Reserve window in advance, and then loan you digits based on that. All that money goes into an account. Then they, quote unquote, give you digits, pay for the house, and then send you an invoice to keep paying. Then I can go on and on and on about what they do with that. So the question that let's go through your question. It says, is it sufficient to protect me from government? Do you do allodial titles? How much would that cost? Having a mailbox on property, would that compromise the allodial title? Do I take my property out of the trust and put it into allodial title? All right, so we don't sell allodial title. That belongs, everything on this earth belongs to God. So when I look at the term allodial, I'm looking at something that is raw, no liens or encumbrances, never been registered in any county recorder, and if it has, it was properly removed from the county recorder, and it sits on patented land. So let me give you an answer to your question that I think you'll find acceptable. Everything's been issued in this nation and considered as structural land. That is, so if it's recorded in a county recorder, it's considered property. It's territory. It's 6 inches above the land. Again, if it's recorded in the county recorder, it's considered property. Why? Because when you look at every deed of trust, it's a legal description. It's not meets and bounds. It's not describing land. It's describing a region or area and territory. The federal government owns all territory. It actually goes all the way to the Vatican. Don't want to get into that. So what are we trying to do? We're trying to effectively, and I'm not mincing words, I'm being very specific, because allodial is it's a far-reaching term. But sitting on patented land is doable. Accepting the patent that doesn't belong to you and recording the patent in the county recorder is the mistake of everybody. Accepting the patent that you're sitting on and then serving constructive notice that you own the patent, you're the patent holder, you're the patent rights have passed to you, it's all bullcrap, in my opinion. Does some of it work under color of law and actions of foreclosure? Maybe. But to remove the property from being registered within the county recorder and pulling it out of the county and unregistering it, now you're sitting on patented land and you're no longer getting invoiced. Does that mean police officers or cops know that? No. They don't know what a state citizen is. They don't know what allodial is. They don't know what patented land is. They don't know what rights are. They don't know anything as it relates to even the law that they're supposed to uphold, support, protect, and defend. And they certainly don't know their oath of office. So these questions you have to really think through. Are they going to, is it going to stop government from coming onto your property? That's like me saying, I know every branch, every police agency, every military, I couldn't possibly truthfully answer that question. Do they have a right to come onto patented land? No. Do they have a right to come onto land that is unrecorded and unregistered? In their mind, yes. Lawfully, no. They only have a right as the federal government or even a state, which is a sub of the federal government, to come onto private land. Remember, the United States' exclusive jurisdiction is in the District of Columbia. And everywhere that they hold the American flag with the gold fringe around it, like the federal buildings, United States post offices, and other places where the state has conceded those areas or regions to the federal government is truly the only place that they have lawful right to have jurisdiction over. So everything else is by color of law jurisdiction. So let's start there. To have me try to answer you as to whether they're going to be able to come on your land lawfully, legally, no. If you're sitting on patented land, whether you own it or not, that is unregistered from a county recorder, that your house sits on, that has already been paid for, that's a whole nother story. But here in this nation, we have a structural system that protects us by international treaty law and hundreds of Supreme Court rulings. They don't put this in the code of the United States. They don't put this in the Uniform Commercial Code or United States Code. They put this in Supreme Court rulings. State citizens are not United States citizens and are completely free and exempt of U.S. code. But the bottom line, to answer your question, is take the property out of the county recorder, but it's got to be paid for, and with no encumbrances, no liens on it. Pull it out of the county recorder. Every county is different. They have a form. You can FOIA the form. I'd like to pull my property out of the county recorder. What is the form to do that? They're not going to respond. Then you can create your own form and do it through a notice. I've done a couple different calls on this. I've had people have success at this. We do not do this for people because it is labor intensive, and every single county is different, and the level of fight is different. So that's why. Hope that answers your question.